Okay, so once again, welcome to our class. And the topic that we are going to be considering today is topic 4 on our course content, which is the structure of court system in Nigeria. The structure of court system in Nigeria. And under this, we are going to explore the meaning of courts, classification of courts too. This entire structure of court system in Nigeria and the meaning of courts, both topics form our topic 4 and 5. Even though the sub-content is a bit lengthy, but we are going to cover them under this topic 4 and 5. Okay. Yeah, Oparaji, you have a question?
Yes, sir. Good morning, sir.
Morning.
So we've not done topic 3, that is mystery of the Nigerian judicial system.
Yes, I've asked that you read that up. We treated that too in the first semester, just to prevent a repetition. Or you
Okay,
can also check my lectures online for just to refresh your memory on that. Okay,
okay, sir.
so let's move into the topic, structure of court system in Nigeria, meaning of court, and classification, also, and the hierarchy of courts in Nigeria. By way of introduction, it is important for us to know or to have a good knowledge of court system in Nigeria, as well as the hierarchy of the Nigerian courts. This is very essential, and it also helps us in appreciating the position and jurisdiction of our courts. The courts of law in Nigeria and even elsewhere are constituted according to the law setting the courts up. And by reason of this composition, there are, there are things that are, are important to note, which may cut across understanding the jurisdiction of courts, understanding the powers of courts, understanding the number of judges or justices that can preside over a matter, and also the kind of matters that they can attend to. So this aspect also exposes us to the what is important about our court system, and also the degree of law of a decision, of case or precedent. And of course, the word precedent may not be new to us, but by virtue of understanding the composition and the structure of court, we begin to have a deeper knowledge of what we mean by the by precedent. And I believe by the time we are done with this aspect of the course, you will understand better how the doctrine of judicial precedent works. So, and we'll see that in clear term. And of course, like we know that the judgment of the highest court in Nigeria, those are the Supreme Court and the Court of Appeal, which has several divisions in various parts of the country, from time to time, command great respect. That is because of the hierarchy or the position they occupy in our judicial system. So we know that the judicial powers of the federation and of the state or the federation are vested in the courts. We look at Section 6 of the Constitution of Federal Republic of Nigeria 1999 as amended. The content of that section talks about the judicial power of the federation and the state. And the term judicial powers will also include the inherent powers of a court of law and the sanction they can impose. Now, what that means is that apart from the clear powers that may have been stated by the Constitution, there are also what we call inherent powers. Take, for instance, if you are bringing a prayer before the court to grant you the permission, permit me to use this literal word or just this simple word to explain this to you. You are bringing a prayer before court, which in legal parlance is known as a motion or a prayer, that the court should allow you to serve your opponent in a case that is before the court through substituted means. Probably, of course, when you're talking about substituted serving via substituted means, it connotes that effort has been made to serve the opponent the necessary court processes, but for one reason or the other, they are not available to take delivery of the process. The court's practice is that such individual will come to court asking the court, by virtue of particular section of the law, to allow him serve on the defendant the processes through or via what we call substituted means, which can be either by pasting it at the entrance or the office of the opponent, or by sending it via mail, or by sending it via WhatsApp, as the case may be. Those are means of serving an individual through substituted means. Now, when you bring such prayer to court, you refer the court to the section of the law that permits the court to grant you that permission or that prayers. And we also state on that motion paper that the court is empowered under section this and this to grant me the leave to serve by substituted means. And we also add that under the inherent jurisdiction of the court, one of the inherent jurisdiction of the court that we know but not usually written is the fact that the court of law have jurisdiction to do justice or to ensure that justice is done in whatever case is before it. And the only way justice can be done is if a party is properly served with the required court processes, so that the party is not taken aback or taken by surprise. One of the ways for the court to do justice is to ensure that that individual gets the process as at when due. So meaning, even if you have not come under the right law or the specific law that enables the court to give you the permission to go and serve him by email, the inherent powers of the court is that justice must be done. And the court at every point in time will give orders and directive that will make you to do what you have to do for justice to be done. So what we are saying in essence is that there are powers that lie within the court that enables them to discharge their duties and to do what will bring justice to the various parties that are involved in a particular action. And this duty is so important that the court must at all times ensure that they play and act in a way to be able to bring justice to the cases before them. Yeah, Omotosho, I can see you raising your hand. You have a question? You have a question? Okay, let's go on. Maybe that was a mistake. So, the judicial powers of the Federation, like I said, are vested in the courts. And the term judicial power include the inherent powers of the court of law, which I've just explained in a simplified form. And it also contains the sanctions that they can impose. You do, as an individual, you cannot walk into a courtroom and your actions is disrupting the flow of the court. The court can right there and then have you arrested because what you are doing amounts to activities that can affect the proceedings of courts. And again, the court can impose punishment on you. That's why sometimes when you go into the court and you fail to put your phone off or on silence, and it happens to ring in the course of proceedings, the court of law does not have any duty to go and be looking at the law as to what should be done to you. The court can simply ask that you be detained or the phone be seized and then, probably kept for a while, or, the court will decide what and what to do with it. So now when we will look at the Constitution as listed, Section 6 of the Constitution of the Federal Republic of Nigeria, it provides that the court will be able to exercise jurisdiction over all matters between persons or between government or authority and any person in Nigeria, and all actions that are related to the proceedings. So, what we then need to know by virtue of this topic is that courts in Nigeria may therefore be classified in several ways. But the most important form of classification are first, the classification into superior and inferior courts. And secondly, we look at classification into courts of record and courts other than courts of record. So we may have different ways to classify them. We may even classify them by the subject matter they attend to. Maybe a court who deals strictly in criminal matters can be classified as a criminal court. The one who deals in election matters can also be treated alike. The one who also deals in employment relations or labor relation matters can also be classified as, labor court. So, but by way of classifying and to be able to understand in details all we need to understand, we are going to start by classifying the court into superior and inferior courts. And for those of us who have seen the course content already, you see that we have listed them in that form. So number one classification we are going to do, like I rightly said earlier, is superior and inferior courts. That's number one. So under this, we submit that the term superior courts refers to the hierarchy of courts in a legal system, with superior court having more powers, more jurisdiction, and authority than the inferior courts. So when we speak of superior and inferior courts, we simply again refer to hierarchy of courts in a legal system with superior courts having more powers, jurisdiction, and authority than inferior courts. Even to a layman who may probably not understand or know the details that is attached to law, we know that there is a court called the Supreme Court who has a final say on all matters that comes before it. If you go to the Supreme Court, which is the highest court in Nigeria, and the court has given a verdict and you are not satisfied, officially speaking, there is nowhere you can appeal to. But when we want to look at it from another angle, there's only one place that you can appeal to. But that court does not operate in the way human courts operate. And that is the court of God. And then the question will be, where is the court of God? Where is it situated? How can we approach that court? And that's why when an individual has gone to court and is back and the decisions are not favorable, you only resort to handing over the matter to God. But as a nation, the Supreme Court of Nigeria, or whichever is the highest court in all land, has the final say on any matter. So from that submission alone, we can draw that a magistrate court in Nigeria can give judgment just the way the Supreme Court can give judgment. But the judgment of the Supreme Court, while that is final, the one of the magistrate court can be subject to appeal, meaning that the party who is not satisfied with the decision reached in that case can appeal to the High Court, asking the High Court to review what the lower court has done. And if yet, after the High Court must have done the review, he is not satisfied, he can still go up to the Court of Appeal until it finally lands at the Supreme Court and the court gives a verdict. That verdict or judgment will remain final in cases, that case. If you take your mind back to the election that brought President Bola Ahmed Tinubu to power, that election was challenged at the presidential election tribunals. And then, of course, there were issues that made it to go to whatever the Supreme Court, whichever way. And the judgment given there became final. That's why Alhaji Atiku Abubakar, Mr. Peter Obi, and other people who were not satisfied with the judgment of that court could no longer do anything but to accept what the court has said. So the Superior Court, simply put, deals with powers or higher jurisdiction that the inferior court do not have. So The Superior Court has described it this way because the limit to their jurisdiction are minimal with respect to the type of subject matter that they are permitted to attend to, and even with respect to the value of the subject matter of the case. Now, let me explain that to you. If you have a matter between, let me use the commonest, which is the landlord and tenant relationship, and then you have applied to the magistrate court to determine matters between you. The magistrate court does not have power to award any financial cost that is more than 10 million. So, if you have a tenancy matter where you are asking either your tenant to pay you 50 million, that is already above what the magistrate court can attend to. Consequently, we will say that the magistrate court does not have jurisdiction. But look at the Court of Appeal or the Supreme Court. They do not have limits as to the financial cost they can make. Or, for example, when there are issues with election and parties need to go to court, as they will say, if you are not satisfied with the judgment of, the announcement or the declaration as made by INEC, go to court. That kind of a case can only go to some specific courts. So, if a court does not have power to accept and listen to such cases, meaning that the court lacks jurisdiction. So, when we ascribe superior court to courts that have power, greater power, jurisdiction, all of that pertains to the value of the subject matter and the type of subject matter that is before the court. In Nigeria, superior courts are also known as higher courts or appellate courts. The Court of Appeal, by the word appeal court or court of appeal, is one of the higher courts we have in Nigeria because it can receive appeal from the lower courts, same as the Supreme Court that can receive or take appeal from the Court of Appeal below it, and even the High Court and other court, whether the Federal High Court, whether the National Industrial Court, as the case may be. So, therefore, they have appellate jurisdiction, they are higher courts, and they also have broader jurisdiction and powers. I've explained that earlier. Meaning they also handle more serious cases. For example, if there's an alleged case of a murder, you can't charge such a person to the magistrate court to be tried there because the power of the magistrate is limited and cannot attend to murder cases. So consequently, the magistrate court does not have jurisdiction to attend to murder cases. But the higher court, that is the superior court, talk about the High Court, talk about Court of Appeal, and Supreme Court can entertain such matter. And we also refer to this superior court as superior court because they have the authority to review and overturn decisions made by inferior courts. So if you are asked what makes the superior court different from other courts, your answers have already been provided. But to confirm that people are following us in this class, I would like to ask, what are the reasons behind calling the higher court superior court in Nigeria? I want answers, please. Anyone who has been following us and who understand what we are talking about.
Hi, sir. Good morning, sir.
Morning. Yeah, they're doing.
Yes,
Go
sir.
ahead.
So I said the superior courts are referred to the higher court because they have the power to to view and overthrow any decision made in any lower court that is brought to the higher court, sir.
That's one. Yes, Mausi.
Good morning, sir. You said while the Supreme Court and the Magistrate Court can both make decisions or judgments, or any lower courts can both make decisions and judgments, that of the Superior Court, which is the Supreme Court, is final, while that of the Magistrate Court is open to appeal. That is, if the subject is not okay with
All right. That's beautiful. Sonny, can we have you?
Yes, sir. So you also said that the superior court deals with power and jurisdiction that the inferior court does not have.
Okay. All right. That's fine. Thank you very much. So those are the major points to distinguish between the superior court and the inferior court. Now, let's look at examples of superior court. So we say that superior court include the following. Number one, the Supreme Court. The Supreme Court. The court is the highest court in Nigeria with final authority on matters of law and constitutionality. So Supreme Court is one of the superior court in Nigeria. Another superior court is the appellate court. Appellate court. And those are the courts that hear appeals from lower courts receiving decisions. I'll call it, let's use the word appeal court. So after the Supreme Court, we have the appeal court. Number three is the Federal High Court. Federal High Court is also another superior court in Nigeria. Okay? And also the fourth on the list is the High Court. And mind you, there is High Court in all states of the Federation. That's why you have High Court of Lagos, High Court of Oyo State, you have High Court of Bayelsa State, and so on and so forth. So, in some countries, a high court is the highest court in their particular region. But in Nigeria, it is not. That name high court is only used when describing that court. But when you use the word higher court, the high court is part of the high court, which is the name of a court in Nigeria, is part. Same also for Court of Appeal, same for Supreme Court and the Federal High Court. So the High Court of a state is a superior court, for it has jurisdiction throughout the state with respect to the value of a subject matter. So with that, we see the court that makes up the superior court. Now, before we move into the next one, which are the inferior court, Agbodule is raising hand, probably to ask a question. Yes, the floor is for you.
Good morning, sir.
Morning.
Yes, sir, I want to ask a question.
Please go ahead.
Now, between all these four examples of superior courts that you listed,
Yes.
you made me to understand that the Supreme Court is the most powerful.
Very well, sir.
Does that mean that a judgment received from High Court, you can still take it to the appellate court for
Yes.
review?
Yes, please.
All right, sir. Thank you, sir.
But yeah, let me just clarify something. You know, the knowledge you may have gotten from my explanation is that once a judgment of a court is subject to review, meaning that that court is an inferior court, not necessarily so. High courts in Nigeria has been classified as a superior court. Therefore, but there is provision that if you are not satisfied with the decision of the High Court, you can still take it up to the next higher court to it. So don't let us get it twisted. Yes, blessing Osama. Osama Gay, you have a question? Please go ahead.
Morning, sir.
Morning.
Sir, you said something concerning the magistrate court. You said it does not have the power to decide cases concerning murder, right?
Yes, please.
Can we also say that the magistrate court is basically does only civil cases?
No.
Okay, sir.
Magistrate courts attends to both civil and criminal cases. Apart from murder, which other crime do you know in Nigeria?
They are armed robbery and burglary and the rest.
And the rest. Which one have you committed before? Which criminal offense have you committed before? You are laughing. Answer now. If you have not committed any, let me know. Okay, that's just the lighter part of it. Now, apart from murder, armed robbery, rape, attempted murder, of course, all of those crimes are tagged serious crimes in Nigeria. There are other criminal offenses like theft, theft, maybe of some little things. It can even be assault. You hit someone against the person's wish. That is a criminal matter. Or you do what we popularly call 419 in Nigeria. You obtain under false pretenses. All of those are criminal matters that the magistrate court can hear. But matters that are very severe and cannot be entertained by the magistrate court. Okay? I think you are okay now. We can move on with that. So, inferior court. So, we said on the other hand, the inferior courts are courts which have jurisdictional limits with respect to the type and the value of subject matter. I believe that with the explanation that we have provided so far, you understand what we mean by the types of cases and the value of the subject matter. So inferior courts are normally and generally subject to supervisory jurisdiction of superior courts. And mind you, when you want to talk about superior and inferior courts and you bring two courts together, for example, you bring you bring Supreme Court and Court of Appeal. To Supreme Court, Court of Appeal is inferior, is a junior court, so to speak. But that doesn't take the appellate jurisdiction or the power of the Court of Appeal away from it. But generally speaking, those lower courts that their activities are generally subjected to supervisory jurisdiction are the ones we call the inferior court. Another name that we can call the inferior courts is lower courts or subordinate courts. Okay, lower court or subordinate court. Why? Simply because they have limited jurisdiction. So we have examples here. Apart from the fact that they have limited jurisdiction, they handle similar matters. They handle less complex matters, not cases that are so complex that it will need the higher judge with higher experience and qualification to untap. So, examples are these. Number one, the magistrate courts. The magistrate court is an inferior court in Nigeria that handle pre-trial matters. They handle minor crimes, like I said earlier, and cases involving small amounts of money. If you are somebody is owing you 500,000, 2 million naira, 3 million naira, the court will be glad to hear and determine such matters. So, another one of the inferior courts that we have in Nigeria is the mobile courts. These mobile courts, they handle local matters such as traffic offenses or traffic violations. They handle matters relating to minor criminal offenses. So, magistrate courts, mobile courts, and small claim courts are inferior courts within our system. And of course, like I said, small claim courts, they handle civil cases involving small amount of money, usually a certain amount of money, a determinable amount of money. So, among the inferior courts, like I said, we have the magistrate courts, we have the mobile courts, we have the small claim court, and we also have traffic courts. They handle traffic violations and other matters related thereto. For those who have been arrested by LASTMA and were not able to clear their ways before leaving the road, they may have, one way or one time or the other, attended these traffic courts that I just mentioned. Now, let's look at the differences between inferior court and superior courts. Okay? Number one is jurisdiction. Okay, I think I've asked that question, so there's really no need to, ask you again. Jurisdiction. That's number one major difference. The superior court have broader jurisdiction, while inferior court have limited jurisdiction. Number two is authority. Superior courts have more authority and power than inferior courts. Number three is appeals. Number one is jurisdiction, number two is authority, number three is appeal. That is, decision made by inferior courts can be appealed to superior court, but decisions made by superior court are usually final and binding. I need to also mention that there are some classes of cases that when they get to court of appeal, that is their final court. They cannot go beyond that court. So, In essence, what we say is that depending on the kind of case that is involved, there are some cases that does not go beyond the Court of Appeal. So we have listed first jurisdiction, that's first difference. We have listed authority, we have listed appeal, and then the fourth difference is complexity. Superior Court handle more complex and serious cases, while inferior court handle smaller and less complex. Okay, so that's gives us the general summary that we need about superior and inferior court. Okay, I would like to take question and then we can end it here for today. I do not want to load up because I have another tutorial class in a few minutes time. So do we have question? I think there is a question. Yes, please. Okay. Someone is asking from the question and answer page. Person is saying, sir, does it mean that these higher courts do not take on any cases or any case except from appellate cases? This question is from somebody who is really in this class. Very intelligent question. Yes, thank you for asking. They take on cases that are not coming from appeal. What it means is that they have their own original jurisdiction. There are cases that must start from, they have classes of cases that can only start from there. For example, the Presidential Election Tribunal matters falls within that class of a case. There are also constitutional matters that can only start from the Supreme Court, especially if it involves the president, or there are those cases are really classified in that form. So it's very easy to identify. Okay, so the Supreme Court have their original jurisdiction. Later on, we'll be talking about the number of judges that can sit when they are attending to matters that comes under their original jurisdiction, and also when they are entertaining matters that comes during or when they are sitting as appellate courts. So the truth is that they have other cases they can take on and not necessarily those on appeal. Yes, Akinubi Favor.
Good morning, sir. Sir, please, what are the cases that cannot go beyond Court of Appeal and why?
Okay. I just gave you example of the Presidential Election Tribunal. Now, one thing you need to understand is that the courts have been structured to have areas that they are to handle for organizational sake. For organization's sake. Because if you don't structure it like that, that means anybody can, the process will be abused in that anybody can go and start a case anywhere, whether it's something that can be treated at the lower court. So that's why the court system is structured in the way that those courts have what that they can undo. Okay? And it's a design of law, not just an arbitrary decision. Okay? So those cases are the cases that have been tagged that, oh, this Court of Appeal, they have their original jurisdiction in this particular case. And then when we're talking about those cases, there are the cases that we say that they have their original jurisdiction. Okay? And again, like cases that pertains to enforcement of fundamental rights, maybe under Section 46(2) of the Constitution, can also include cases that Court of Appeal can start as their original jurisdiction. But to simply answer your question, the reason why it's like that is because the law has said so. Just like you are a student of University of Lagos, and the law has said before you can be admitted as a student, you must fulfill certain requirements. Or the level you are now, you cannot take on courses that are in 500 level. The question will be why? The university has designed it to be so based on certain factors. So the same thing applies to court here. Okay?
Okay, thank you, sir.
You're welcome. So we call it a day here in the absence. Okay, some people have asked a question. Let me quickly do that within 1 minute. He says, sir, can you repeat what you said about appeal as different from the two courts? Which two courts? You didn't specify. Sir, do mobile court handle similar cases with traffic courts? Yes. Those are minor cases. Okay? Those are minor cases. Then someone is asking, my question is, if a case can be reappealed to the same court, e.g., the same case being brought before the Supreme Court a second time, even after a judgment must have been reached. Well, this is not usually the practice. Okay? It is not an allowable practice in our system. The only thing is that if there is a case that has been decided by the Supreme Court, another case that is currently before it can cite that case, whether with the view of making the court to realize if they made an error in that previous case and then to correct. So you cannot reappeal a case because there's what we call res judicata in law, that there must be an end to litigation. Because if you do it that way, that means every loser on such cases will continue to, seek for appeal. So that is my response to those questions there. So with that, we call it a day. Thank you very much for staying with us and enjoy the rest of the holiday. Thank you very much.
Thank you, sir.
Thank you, sir. Thank you, sir.
Thank you, sir.